Are police reports admissible in Tennessee? Hi, I'm John Griffith. I'm a personal injury trial lawyer practicing law in the state of Tennessee. Every time I have a case with a client of mine and the defendant is denying fault, they always say the same thing. But the police officer in the police report says this other person's at fault. Is that admissible? Not necessarily. By law, specifically, police reports are not admissible in Tennessee. That is surprising. Why is that? Because an officer is not there when a car wreck first happens. He does not see what happens. He or she does not witness the events as they occur. A police officer can testify as to things they observe once they are on the scene, such as the position of the vehicles as they're sitting in the roadway, the condition of you as the injured party, things that you say to the police officer about the nature and severity of your injuries, things that the defendant says, the condition of the defendant, whether the officer thinks that the defendant was under the influence of drugs or alcohol. All of those things are admissible if the officer sees them firsthand. Otherwise, they fall into a category of evidence of hearsay or speculation that's not admissible, and the report, most importantly, specifically, is not admissible. There's one exception to this rule that I've used for my clients' benefit, and that is if the officer draws the cars in their resting state after a car wreck on his narrative on the back of the police report. I have been able to get that admitted as a recollection of what the officer actually saw with his or her own eyes. Other than that, the police report themselves are not admissible and a jury is never allowed to see them. If you have questions about your case, call me. I'm here to help. I can be reached at 615-807-7900 or email me at john@griffithinjurylaw.com.